Good afternoon to everyone. Thank you so much for joining us. My name is Alice Hogan, and I'm the Navajo Arlington Director. We also have with us today Jill Norcross, Executive Director of Overall Navajo, and Hannah Matuda, who is the Policy Director here at Navajo. We host these lunch and learns each month at noontime. The day varies, but feel free to keep an eye out for future lunch and learns. We will go for about an hour, and today we are going to be discussing tenant advocacy and know your rights, which is top of mind in a lot of practitioners and residents in the Northern Virginia area. So we want to welcome our guests who will be discussing tenants' rights, protections against discrimination, eviction issues, special challenges that our immigrant families face with regard to displacement or rent burdens, those kinds of things. And then at the end, we'll take a question and answer period as well. So many of you sent in questions, and so we have those, and our presenters have tried to incorporate some of those questions, the answers to those questions into their presentation. So hopefully that will help. So I wanted to introduce, we have two colleagues in the, greater immigration, housing advocate community from the Legal Aid Justice Center. And so we welcome Larissa Zaire, and her coworker is Catherine Cohn, and they are here to share their insights. They're lawyers in the field. And then, as I said, we'll take some questions at the end. So I wanted to welcome Larissa and Catherine. Thank you both so much for joining us. It's obviously a very hot topic. This is the highest attendance in a lunch and learn we've ever had. So clearly people are very interested, curious to learn from you all. So thank you again. And I guess, Larissa, you'll get us started.
Thanks very much, Alice. And thank you, everyone, for taking the time to join and talk about these important issues today. So we're just going to jump right in. I am going to be sharing some slides, and Catherine and I will be trading off presenting. But we are both attorneys with the Legal Aid Justice Center. So we're a statewide organization. Catherine and I both work in the Housing and Consumer Justice Program. I'm a senior attorney, and Catherine is our legal director. And we, in that program, we do lots of different things, advocating for housing justice and consumer justice across the state of Virginia. We'll talk about some of those things today, but that includes we represent tenants in eviction court, and in affirmative actions. We also do fair housing work, and we do advocacy for policy change at a local and state level. So a couple of things just to set some, just like make some notes at the beginning. This is like just what to expect from today. So this presentation contains some general guidelines for understanding some tenant rights, not all, but some, and the eviction process in Virginia. This is not legal advice. This is some generally applicable legal concepts, but we can't advise on this call of what anyone individually should do. And then tenants in eviction proceedings or with questions about their particular rights, please reach out to us. We'll have information at the end of the presentation. We do, like I said, provide direct legal services. And so we encourage tenants to reach out, and you all also will leave you our contact information to reach out with any questions. So the goals that we'd like to accomplish today, and we'll leave about 15 minutes at the end for questions, but we are going to try to share some basic tenant rights so that advocates can know when to reach out to legal services organizations. We'll also highlight opportunities for local and state level advocacy and collaboration, and we're going to provide a few immigration related resources. So Catherine and I are not immigration attorneys. I know that a lot of folks have questions that are directly related to immigration concerns, but we are not going to answer those on this call. We're going to talk more about the intersection of housing and immigration. So how to advocate for and support immigrant tenants. But we will also link to some immigration related resources if those are of interest. And I'll say, as a legal services organization, we provide free, I didn't say this at the beginning, but just to say we provide free civil legal services to anyone. We don't, regardless of immigration status, at Legal Aid Justice Center. And so that's just another piece of information about who we are. Okay, so I'm going to start with some numbers, but I also feel like these are all things that if you live in Northern Virginia and work in Northern Virginia, you know how important and how wonderful this community really is. It's such a rich and diverse community. There are so many strong and immigrant communities in Northern Virginia. And I think we also all know just how much inequality we see in the housing system in Northern Virginia. So here, I'm just going to set some statistics at the beginning, but this comes from a 2021 study from the Community Foundation for Northern Virginia, but it found a pretty shocking, or pretty, I don't know, maybe not shocking in terms of surprising, but a pretty dramatic statistic, which is that low-income Northern Virginians, those are folks who earn less than 200% of the federal poverty level, or about $50,000 for a family of four, are the most severely rent-burdened group of people in the country among large metro areas. So that means we're really seeing extremely severe rent burdens in this area. 2/3 of low-income Northern Virginians are severely rent burdened, and that means paying more than half of their income in rent. So just thinking about that for ourselves, like what does that look like to be spending half of what you earn every month just on rent, and whatever's left over is what covers everything else, has to cover everything else your family needs. And this is disproportionately high for racial and ethnic minorities and immigrant communities. 47% of severely housing burdened families were born in a different country or had members who were born in a different country. And so it's disproportionately higher for immigrant families. And this study was from 2021, but rents have only continued to increase. And also, we know that the area median income averages of the area have also increased. So the region is becoming wealthier on the top end, but also but low income Northern Virginians are not earning more, but their rents are going up increasingly. So the situation has continued to trend in a really negative direction since the study happened. And just a statistical example of that rent increases. So since 2019, Prince William County saw an average, which means there's, for everyone who has less, there's folks who have a lot higher, rent increase of 33%, and that was 7.9% in just 2023. So for a family paying $2,000 in rent, that's a $158 a month increase, the 7.9%. So in just 1 year, $158 a month increase. Those are really difficult to sustain. So what this looks like families, especially immigrant families, being pushed out of the region, needing to move to areas that are farther away from their jobs, needing to leave their schools. And it really looks like intense housing instability. So I'll say a little bit at LAJC, what we try to do is we recognize that the housing system is not it's not constructed to create an equitable system for especially Black, Indigenous, Asian American, Latine people, and also for immigrant families. And so we try to work at a statewide level, local level, and on individual levels to try to create a more equitable system. And before I jump in, we're going to talk about some legal frameworks and a bunch of different information today. But I also just want to highlight that there are some really incredible immigrant-led organizations in Northern Virginia that are doing the work to say what their communities need and the types of resources they've been doing this work for many decades. And I would just encourage you all to reach out to them and And now is our chance to really listen, hear what they're saying, and respond in the ways we can to try to make a more equitable system. Some of those organizations are probably on this call, but Tenants and Workers United, Bugata, La Colectiva, Virginia Coalition for Immigrant Rights, and African Communities Together. Those are some of the partners we work with frequently, but there are many more as well. So, okay, with that out of the way, I'm going to talk about a little bit of the legal frameworks that do apply to tenants and immigrant tenants as well. So we have the Virginia Residential Landlord and Tenant Act. That is the statewide law that applies to rental housing in Virginia. Also the Federal Fair Housing Act and the Virginia Fair Housing Law. And then federally subsidized housing has a whole host of federal regulations, which we're not going to get into on this call. It's a lot more complex. Many of you already know that. But just knowing that the Virginia law is a baseline that applies to all housing, but federally subsidized housing has a lot more specificity of regulation. So the Virginia Residential Landlord and Tenant Act covers tenants in Virginia. It makes no distinction based on immigration status, which means that any person, regardless of their status, has the same rights under Virginia law. One thing that we also share is that civil courts are different and separate from immigration and criminal courts. However, what we are doing right now is the Trump administration issues a whole host of changes in how immigration and customs enforcement does basically immigration enforcement activity. We're monitoring very closely how this enforcement activity changes might influence civil courts. But generally civil courts are separate and immigration status has no relevance to people's civil cases, so to a housing case. If immigration status is coming up for a tenant, if it's something that's becoming an issue, if the landlord is raising it, that actually is a sign to us that there might be discrimination or retaliatory conduct occurring. And those are the types of issues where we would want people to reach out. But generally, there's no reason why someone's immigration status should impact their rights under the Virginia law. Also, this is a random, but I think important that it's very common for tenants in Virginia to have a lease. Some tenants have verbal leases, or their lease they might have signed a lease many, many years ago and continue living in the property. They are still covered under Virginia law. So tenants generally have the same rights, even if their lease is not current. Just because the last lease you signed might have been in 2015 doesn't mean that you suddenly are not protected. And this is just the citation for the code. So the VRLTA, as we call it, sets some baseline tenant protections that apply in private, public housing, subsidized housing as well. So one of the protections is fee transparency. So a landlord must state on the first page of the lease all rent and fees due. This actually was a result of a lot of advocacy and changed in 2024. And so this is something that really helps. And I'll try to highlight where some of these protections particularly help immigrant tenants. But this one, often leases are very long and they're often only in English. And so limited English proficient folks have a harder time digging through the many addendums that might have a small fee for something, and then are more likely to get behind based on, something that was a misunderstanding at the time that they signed the lease. And so the fee transparency is really to help folks understand this is what's owed monthly in this property, and to prevent misunderstandings or prevent issues later on. Other protections, there's a standard late fee provision. Go back one. Okay. Standard late fee provision, which is that late fees can only be 10% of the monthly rent or the amount owed. And then it has some basics around maintenance. So a landlord must keep a property in fit and habitable condition. And and remedy conditions that threaten a tenant's health and safety. There were a few questions from you all about mold. Landlord must also prevent and promptly remediate any mold. And so that's another landlord obligation under the Virginia law. And a landlord must maintain the unit in compliance with building code. So some of the basics of the building code: each local government has a code enforcement branch, and they will inspect for compliance with building code for things like heat, air conditioning, hot water, and to remedy rat and mice and other pest infestations. Another baseline protection in the Virginia law is about retaliation and organizing. So Virginia, or tenants in Virginia, have a right to organize. That means they have a right to form a tenants association, to make complaints or raise issues or request maintenance from their landlord. And the Virginia law prohibits a landlord from retaliating, decreasing services, threatening to evict a tenant, or evicting a tenant if the landlord knows that the tenant is organizing or has made a type of complaint. And so this is something, again, we heard some questions from you all about, what is the baseline in terms of organizing? And definitely, I think these are important things to keep in mind as tenants are considering reaching out about their needs and their rights. Okay, I'm going to talk a little bit about the eviction process. Again, this is to get some baseline information to you all, and think about times when you might want to reach out to legal services. And I'll include the information too of the different legal services organizations that tenants can feel free to reach out to. So the eviction process in Virginia starts with a written notice. This is the first step, and it's required before a landlord can sue for eviction. And honestly, I think these notices are an important opportunity for to try to attempt to resolve any issues with the tenant before it's necessary to resort to court process. So the 5-day pay or quit is what that does is it gives a tenant 5 days to pay any past due rent. And there is actually 30-day notices required for some federally subsidized properties. That is about a rent-based issue. So that gives a tenant the opportunity to say, oh, this is how much I owe, and I can get up to date. There's what's called a 2130 notice, which gives a tenant 21 days to fix any non-rent breach of the lease. So it's what that notice has to do is sort of tell a tenant what the issue is and give the tenant 21 days to resolve the problem. And then if the problem isn't resolved in that time, then a landlord could proceed to try to take the tenant to court. And also sometimes we see 30-day notices to vacate, which is given to end a tenancy, specifically a month-to-month tenancy. So I want to highlight something here, which is something that we see fairly frequently, and why we think talking about the eviction process and tenants' rights is important is because rates of self-eviction are fairly high. What that means, or we see often people self-evicting, and what that means is people moving out without knowing that they have the opportunity to try to resolve the issue either before the court process or during the court process. This is especially a risk we see for immigrant tenants who may be fearful of attending a court process. And so I think one of the issues we really want to encourage people now is to try to refer folks to legal services as soon as possible and as early as possible in the process, because we can help folks understand their rights. And also there might be ways to help them defend themselves and minimize the risk of attending court. Like I said, civil court is separate from immigration and criminal court, and usually immigration status is not relevant, but we understand the fears, and we're used to talking that through with people. And so we really think proactive outreach, proactive understanding, or like reaching out to people who might be facing eviction. Even at the stage of receiving a letter from the landlord, we would really welcome people to reach out to us at that stage and not waiting for a court process to start to see if if there's anything that can be resolved. We can also share with folks that the only person who can evict a tenant is a judge. And so they have to go through, is the sheriff with an order from a judge. So they has to go through the entire eviction process before someone can actually be evicted. And there's usually multiple opportunities to resolve the issues along the way. And so I think that's especially important now, is to encourage people to reach out to legal services. This, I won't go into a lot of depth, but this is what the summons looks like. So this is the sort of the start to an unlawful detainer or an eviction case. And then the eviction process usually takes place in two court dates. One is the first return, where a tenant is able to attend court and ask for a trial. If there's an emergency and the tenant can't attend the court, or if they didn't have proper notice, they might, and they get what's called a default judgment, which is a judgment in their absence. They have the opportunity to motion to reopen or rehear the first case, and provide the court the reason they weren't able to attend the first return. But we think attending the first return is really important to try to avoid those default judgments. Some folks had asked about interpretation. So in these courts, interpretation is available. The general district courts are required to give litigants, give people who are in the court process the opportunity to access interpretation. Spanish interpreters are typically more available in the courts, but it is different court by court. And so calling the clerk is usually the best bet to try to figure out what you need to do in order to request an interpreter. In most courts, any other language I would say in all the courts, any other language except Spanish requires a request ahead of time. And so but there is interpretation available, you just have to let the court know. And then when there's a trial date, after the trial, depending on the court's decision, there's a 10-day appeal period before the writ of eviction can be served, and the writ of eviction will have 72 hours notice from the sheriff. So a writ will say, we will be evicting you, but within 3 days. And so it gives a tenant an opportunity to leave. One really important right in Virginia is the right to redeem, which means a tenant can pay the total amount due, including current rent and all the court-related costs, up to 48 hours before the eviction. That's before the sheriff's notice says that the tenant has to leave, and they can stay in their property. And so again, like I said, there's a lot of opportunities to resolve the issues before someone is actually evicted. And it's important to know that those chances exist, and to try to help people stay in their homes. So I want to talk a little bit about access to rental assistance. So we generally, for rental assistance, proof of immigration status is not required. And one thing that we think is important is for providers of rental assistance to clarify that with applicants, that there's a lot of fear related to the public charge rule, especially that we experienced during the last Trump administration. But essentially at this point, the public charge rule has not changed. And rental assistance has never been, not even in the previous Trump administration, considered something relevant to the public charge rule. So I'm not going to go into a ton more detail about public charge at this point, but short-term emergency relief like rental assistance is generally not considered relevant. It was not, even during the previous Trump administration, considered relevant to public charge. And so that's another thing that's important to clarify. We are also going to be paying a lot of attention to any potential change in this, and I'm sure you all will as well. But currently, access to rental assistance should not have any immigration implications for folks. I think also it's important to keep considering mutual aid and other independent sources of rental assistance that aren't that folks can access in their churches or in their other community spaces, because they're, like we said, these types of things are really important because folks are so rent burdened. One other important thing that we wanted to share about immigration and access to housing. So maybe this is, one of the most relevant pieces of information right now, but under Virginia law, landlords are allowed to request information from a tenant that helps them determine the tenant's eligibility for housing. And the Virginia law specifically states that can be a social security number or an individual taxpayer identification number. So a social security number is not required. Virginia law gives a landlord these multiple options, and they're allowed to ask for documentation, but an ITIN can be one of those, or the taxpayer identification number can be one of those. So we think the best practice is not to ask for proof of immigration status from an applicant. Another thing, even in federally subsidized housing, and for instance, the low-income housing tax credit, there's no immigration status requirement to live there or to apply. And even for other federal subsidies where there's mixed status families, families who are eligible must sign a declaration of status, but ineligible family members simply do not declare status. And so, and a person can still have legal status and be ineligible for federal subsidies. So just having the eligibility is not linked directly to being documented or undocumented. And so so the best practice is it's not necessary for landlords to ask for proof of status, and the best practice is actually not to. There was a proposed rule during the Trump administration that would have barred mixed status families from certain types of public and federally subsidized housing. That rule never passed, and we will again be monitoring those changes closely if they attempt to change the rules again. One other thing we know that there are a lot of housing providers on this call, and we think that if housing providers are interested in providing information around immigration and immigration rights to tenants, we think the best practice is to link tenants directly with organizations that provide immigration services like Legal Aid Justice Center or others in the community, especially with the rapidly changing environment. We will share these slides out, so you don't need to take notes, but these are some of the main legal and know your rights resources for tenants' rights. Legal Services of Northern Virginia in this region, Legal Aid Justice Center. We have tenant resources in English and Spanish on our website. And the Virginia Poverty Law Center has a really great how-to guide that is also in English and Spanish for more information. Now I'm going to turn it over to Catherine, who's going to dive into fair housing law.
Hey everyone, good afternoon. Just wanted to do a quick run through of a couple of basics around fair housing law. So again, if you're a landlord or if you're working with tenant communities, it's important to keep in mind that in any housing situation, whether it's rentals, sales, condos, different types of housing, it is unlawful to discriminate against someone because of their membership in a protected class. And as far as like what kinds of laws we're talking about that apply with respect to housing discrimination, it's the Federal Fair Housing Act as well as the Virginia Fair Housing Law. And then with respect to both of these laws, there are a number of different protected classes. So in other words, if you're a member of any one of these classes, then you have that protection from discrimination. The Federal Fair Housing Act is a bit more narrow, so it includes protections on the basis of race, color, national origin, religion, sex, disability, and familial status. One quick note though, although sexual orientation and gender identity have not officially been recognized as protected classes, and this is really getting into the weeds, but there have been some cases where courts have interpreted sexual orientation and gender identity to be part of the protection on the basis of sex. So like the best practice really is to avoid any kind of discrimination, because obviously the goal is to provide fair housing to everyone, regardless of their identity or membership in any protected class. And then under the Virginia Fair Housing Law, there are a couple of additional classes. So those include military status, elderliness, and then source of funds, which I'm guessing a lot of you may be familiar with. So for example, if tenants are attempting to rent a unit with the use of a voucher, that would be one example, or whether it's project-based rental assistance. So any of those types of situations where someone is using some kind of subsidy or other type of source of funds that's not like the typical way of meeting, for example, an income requirement. So if we go to the next slide, we can talk a little bit about who does it apply to. So as far as like, besides the component about membership in a protected class, both laws also recognize that there's certain exceptions. So we can start with the federal fair housing law and then also kind of dive into Virginia. They essentially almost mirror each other. So under both laws, if you are an owner of a single family home where you have 3 or fewer residences, right, then you would be exempt. Now, if you own 4 units or more, then you would be covered and not be exempt. But then the caveat is you also cannot be using an agent, a broker, a realtor, any kind of salesperson, be a realtor yourself, or publish any kind of discriminatory advertisement or notice. So again, like even if you're an owner who has 3 or fewer units, if you are using an agent or a broker, or if you make any kind of advertisement that, for example, says like we don't take in the Commonwealth of Virginia, we don't take any vouchers, then that would still be discrimination and a violation of the law, because regardless of whether you have 3 or fewer units that you own, you would still be making that kind of discriminatory advertisement. Same with respect to if you were using a realtor. Then there's a separate exception that talks about owner occupied units, and the scenario there is often referred to as like the Mrs. Murphy exception. So if you own a home, but you, the owner, are living in one of the rooms in the dwelling that contains 4 or fewer units, then you are also exempt from both laws. I think the real takeaway for those who are in the business of renting and selling is that you really should not be making any kinds of discriminatory statements or advertisements. And I think in this group, like a lot of this is very basic and goes without saying that you're already doing these things. But I know sometimes there's a lot of question around what are the administrative burdens with respect to renting to people with vouchers. So it's like important to make sure that none of your advertisements would sort of discourage the use of any kind of subsidies, just using the source of funds protected class as an example, especially if you're not one of the types of, if you don't fall under one of the exemptions under either of these laws. And then in my particular example, obviously you would be excluded under federal fair housing law because source of funds has not been recognized, but in Virginia, it is a protected class. So as far as like the types of activities that we're talking about, if you're trying to think more concretely, like what are the scenarios, or if you're working with tenant communities, and especially with tenants who are immigrant members, like what would they be looking for to figure out whether or not they've been discriminated against? So it's not just the very obvious, like I'm going to refuse to rent to you or I'm going to refuse to sell to you. It can also be a practice that has the effect. So this language of otherwise making housing unavailable, a practice that has the effect of excluding an entire group of people because of their race or because of their religion or because of the fact that they're using a voucher to rent, or because they don't speak English as a first language, because that would sort of be associated with the characteristic of national origin. You want to make sure that none of the policies in place would potentially exclude folks. So concretely, for example, going back to source of funds, if you say, in order to rent here, we need a co-signer, right? So if you have a voucher, you can only rent here if you have a co-signer. If that type of condition that you're requiring of someone who's using a voucher is different than the kind of conditions or terms that you would normally offer to anybody else who's not using a voucher, then that policy sort of has the effect of and would be a different term and condition that would apply to someone on the basis of their source of funds. So if it's something very blatant, like a different term for one group versus another, that's sort of more intentional, but nonetheless would be a violation. And if it's a policy that, let's say, applies to everyone, it could be, I don't know, everyone needs to show proof of legal status. So that kind of policy could potentially be a violation of the Fair Housing Act, because the people who would be impacted are folks based on their national origin. There were some other examples in the prior slide, but we don't need to necessarily walk through them. We talked about discriminatory ads and statements. There's also misrepresentation of availability, and that includes to a tester. So for those of you who are not familiar with what we mean by testers, there are various fair housing organizations that oftentimes will have volunteers or members of their staff call landlords to see whether you're complying with the law. And they will pose as someone who is looking to rent or looking to rent on behalf of a family member. And so that misrepresentation of availability of a unit to a tester could also be a violation. And then I'm happy to answer if folks have specific questions just to explain what blockbusting and some of these other examples are, but they're mostly self-explanatory. Blockbusting has more to do with discouraging an entire group of folks from remaining in a neighborhood and instead encouraging them to leave because of their membership in a protected class. All right, so then particular scenarios that may violate fair housing laws. I think I already went through one of these. So with respect to folks' concerns around like what more can we do to look out for potentially discriminatory treatment of immigrant households, again, this idea of asking for additional documentation or an additional security deposit to rent an apartment or home, if you're only doing that with respect to immigrant households, but not everyone else, there could be an allegation and a potential violation on the basis of national origin or race, because essentially this policy is treating folks differently because of their national origin or race. Or conversely, you could also argue that the effect of that policy is going to like disproportionately exclude folks who are immigrant households because of their national origin or race. Another example is what I said about having people use a co-signer, but only folks who are trying to rent with vouchers. You could also have policies where management is evicting families with children due to noise complaints, but when it comes to noise complaints for anybody else, they are not enforcing their house rules and regulations in the same manner. So that kind of different treatment with respect to a policy that should otherwise apply the same way to everyone, that could be a flag as well. And then just lastly, requiring applicants to speak English. That's another key example of ways in which we've seen some discriminatory treatment playing out. So that's something to also look out for, as well as like targeting only certain groups for criminal background checks, for example, whether it's Latina applicants or families who have minor children or any other of those scenarios that we talked about. I think that's, oh, yes. And then with respect to language access, I'm happy to take the slide, Larissa. So what we would recommend is that meaningful language access is a best practice. As far as like what the law requires, especially if you're a landlord, the truth is that Title VI of the Civil Rights Act, it applies only to certain types of housing. But of course, we're here to promote, especially for those of you who are wanting to ensure that everyone feels included in your communities, especially if they don't speak English, that you try to comply with the language access requirements of Title VI, even if you do not receive federal funding, because technically Title VI applies only to programs and activities that receive federal financial assistance. So just some like key examples: if you get money for project-based rental assistance, or if you get money and you're a housing authority, so then obviously Title VI would directly apply. But the way that it plays out as far as like how this has been interpreted is, for example, if you're not providing meaningful language access, not only is it discrimination on the basis of national origin, but the way that it could play out is you're not providing key documents to some of your tenant households in languages where let's say in Fairfax County, I don't know off the top of my head what the demographics are, but we know there's a significant Latine population. So if you're receiving those federal funds, but you are not translating these documents and providing them in the key languages where there's a certain percentage of the population that does not speak English, and you are aware of what those other key languages are for the representative populations that live in these communities, then you could be in violation of Title VI. So again, here, like the best practice that we have so far comes out of the Department of Housing and Urban Development, and their guidance requires state and local governments, public housing agencies, and anyone who receives these federal funds, so assisted housing providers, to provide meaningful language access. And we have some examples here. Happy to talk offline, but it's really like having bilingual staff, oral interpretation, written translation of these vital documents, because the goal really is to ensure meaningful accessibility and the same kind of protections offered through a tenancy that would otherwise apply to someone who is English speaking. And then the last thing, as far as the Fair Housing Act, it's not as clear a tie, because obviously there is no protection on the basis of whether you're limited English proficient, but the Fair Housing Act has been interpreted to include discrimination against those who are limited English proficient on the basis of national origin. So again, like if you are imposing different requirements or saying you have to speak English in order to rent here, this could arguably be a violation of the Fair Housing Act.
Great.
That's it for me. I'm going to turn it back to Larissa.
Thanks, Catherine. I'm gonna close by, I know we're getting close to the end of the hour. We want to leave time for questions, but I'm going to close by highlighting some opportunities for advocacy. We would really welcome you all reaching out to us if there are ways you think we can collaborate. And if you'd like to think about opportunities together. One key area, this is an immigration related one, but it's to support local efforts to end and prevent voluntary collaboration with ICE by local governments with Immigration and Customs Enforcement, and urge local governments to not collect or store data about immigration status unless it's required for a specific program, and to clarify those policies with community members when they're applying. We also, and we can talk more about this, but currently one really incredible local program is the Arlington Housing Grant Program. And last year, the county attorney's office determined there's a viable legal argument for Arlington County to provide housing grants without requiring legal status. We linked to the report. You can find it on Arlington County's website. We had advocated for that change, and that has not yet been implemented. We would love to see that, like we said, connecting with everything we've said so far, since our immigrant communities are facing such incredible pressure in terms of rents, and are uniquely vulnerable in our housing system. We think providing resources without legal status or without requiring or collecting legal status information is a way not to expose them in this pretty risky and dangerous environment that we're entering into now, but also to alleviate that rent burden and make sure that our neighbors can stay in their homes make sure that they have the ability to put down roots in their communities, and to just really contribute to their security and stability long term, and all of our communities' stability as well. So highlighting the housing grant program in Arlington. Also, we're advocating for a local housing voucher program in Alexandria, and to expand the guaranteed income program there. I won't enter into depth here. These are just a few things, but we support streamlining certification and application requirements, especially around proof of employment, for immigrant folks. Sometimes proof of employment can be, or just they use different types of documentation depending on the type of employment. And so amplifying what's acceptable can be really helpful in terms of housing access, and strengthening tenant protections and increasing local funding for deeply affordable housing. And then finally, we were not planning to talk much about statewide advocacy today, but just wanted to shout it out. Legal Aid Justice Center also advocates for state law changes. One of the important things about increasing tenant rights is that it can change some of the precariousness and some of the risk for specific particular tenants, so that they're better able to defend their rights. And so we are part of the Allies for Housing Action, and would invite your organizations to join. And some of our priority bills this year are here, currently moving along in the General Assembly. One would allow local governments the option to set yearly rent increase limits, but at the same time guarantee a landlord a fair rate of return on their investment. So that's one. Another would extend the time period to pay from 5 to 14 days before a tenant can be taken to court. And then the final one is really interesting. It would allow a locality to essentially support tenants in enforcing a landlord's failure to maintain a unit. So it helps localities be able to support or back up tenants so they're not on their own in enforcing that right. And then the last thing, we'll send this out, but for those of you who have questions or specifically looking for immigration related information, our immigration team has put together this toolkit. You can find it on our website. I didn't share it at the beginning because I know everybody would click through and then be looking at it while we're doing the presentation, but here it is if you want to look at it when we wrap up today. And this gives some really direct responses to questions that folks have right now about how to best show up for, how to protect themselves as immigrants, and how to best show up for immigrant neighbors. And with that, I will leave you with our information and turn it back over to Alice. Thank you so much.
Larissa, thank you, and Catherine, so much. Very helpful information, and we will be sending out these slides so people can go over them more thoroughly. And thank you so much for offering to work with the groups and individuals who are on the call. That's really, really wonderful. We have a lot of questions and not a lot of time. I would say that if your question isn't answered, we will try to figure that out on our end and get some information back out when we send out our follow-up email, which will include the slides and some other resources that LAJC and also Navaja have been gathering for folks. So look out for that, Friday or Monday, probably. And what else? If you have questions that didn't get answered here, you can also send them to our general email, which is info@navaja.org. And I think Jill will pop that in the chat for us. So many questions. Let's see. Would increasing the rent after making a complaint be a proof of a retaliation to a tenant? I guess that's question number one.
That's a good question. I think our best sort of thoughts around retaliation are to, if you believe that you're experiencing retaliation, to reach out, but also to document your interactions with management. I think or with management or with the owner. I think that's the best way to show, what the relationship is between something like a rent increase and a complaint. That's what I'd say for now, but definitely welcome to reach out with more specifics.
Sure, that idea of documentation and reaching out, that's empowers. Thank you for that. How about the 5-day pay or quit? Can that be given for any amount of rent that's missing?
Yes. I'm going to try to go as quickly as possible, but yes, it can be given for any amount of rent, although the tenant can pay it within those 5 days, and then the landlord can no longer proceed to court.
Okay. And with the 30-day notice, does the landlord need to explain to the tenant what the breach is?
Yes.
Okay, so you
Yes.
can.
And I think really, if we're thinking about, I know a lot of folks on this call are affordable housing providers, and it's really in like a mutual interest to try to keep a long-term stable group of tenants who are like, tenants are wanting to stay in the units and wanting to, have a good relationship. I think it really is a good practice to include as much information about what the actual issue is in those notices so that tenants can actually resolve it. I think that's something that if it's really vague, it's extremely difficult for a tenant to understand how to comply.
Okay. And then you can be evicted for issues that are not involving lack of payment of rent. What do you see as the common other reasons a family might get an eviction notice?
I mean, sometimes I really do think that we see at least are issues that I think can be pretty easily resolved. Things like, a minor lease violation, really, something about like, not, oh my goodness, what's an example? Like not storing, outdoor equipment, like not storing something on the balcony properly. Those are things that we think, someone losing their home over that is really unfortunate. We think those things can really be resolved outside of court, but those are some, they're more related to like minor lease violations. Is probably more common.
Okay, thank you. And then does at least one person in the household have to have and prove legal status in order to receive the federal housing choice voucher in that household? Do you know?
Yeah, that's a great question. So the federal rules actually, and I know we went quickly through that information, so I'm glad someone asked a follow-up. So the federal rules for eligibility for a voucher, for a housing choice voucher, have lists of eligible individuals and ineligible individuals. But even folks with some types of legal status are not eligible. So legal status is not actually automatically, you can be legally present and have status and still not qualify for housing choice voucher. It's not a one-to-one. But for a housing choice voucher, yes, one person in the family does have to be eligible. And then other individuals, and they would have to show proof of legal status, right? Other individuals in the family perfectly fine, can continue living together, can receive the subsidy would be received by the one eligible member, and the other individuals can simply say, I don't wish to declare my status. So they don't have to provide information.
And in that sense, it would be prorated to the number of folks in the household who have documentation.
Yes, that's exactly right.
Okay. All right. And then someone asked about a rodent infestation. They're saying that I can't find the exact one, but that they've been working on this issue for a couple of years and it's not being resolved. And they're wondering what, is that grounds for suing the landlord, or what would a tenant or tenant organization do if they just can't get the resolution they're looking for and a lot of time has gone by?
Yeah, so we didn't cover tenant remedies, like affirmative cases in this. We talked more about the eviction process, but there is a process through which a tenant can do an affirmative complaint against the landlord, either in court for something like a rodent infestation, or through code enforcement. That is something that code enforcement will inspect for. But if you want a little bit more information on like the particular situation you're dealing with, you could definitely email me. My email's right there, and I'm happy to provide a little bit more guidance on what might be a good avenue for that.
Yeah. Do you all help?
I'm so sorry, Alice. On our website, which is justiceforall.org, we have a comprehensive source that describes the different types of remedies for conditions issues. So I'd also point you to that. That will describe the legal options.
Oh, that's perfect. Thank you. Someone put in, do you all help with residents who need to renew their residency status or green card or documentation such as children's passports?
At this moment, that would be more related to our immigration team, and I don't think we do. Catherine, do you want to chime in on that?
Yeah, we do not currently. So I think the best bet is if they wanted to contact us for referrals, we could provide those.
Okay. And I do know that at least the children's passport, if it's just the application, you don't need a legal professional to fill out that form, right? That's the basic application. It will be beyond that you might need a legal professional to assist you with kind of deeper documentation.
I don't know that we are qualified to answer, quite frankly. I don't have the form in front of me.
Sure. Okay, someone is asking, is there any advocacy around prohibiting landlords from charging application-related junk fees, such as non-refundable administrative fees to quote, process a lease at a couple of $100s? And they've seen a few landlords using this tactic where the result is that the applicants aren't able to cover that, so they don't apply after all.
Yeah, that's a really great question. There has been some really interesting, I think, and it's a really common issue, sort of extra fees that then really increase it's like I was talking a little bit about the fee transparency. That's been one thing that at least in the last couple of years has been a big advance, which then requires landlords to at least disclose those fees prior to the tenant signing the lease, and they're on the front page of the lease. And so if it's not on the front page of the lease, a landlord can't charge it. That's one thing I would say. I think also I would pay attention to, if you're interested in getting involved in Allies for Housing Action or other groups, there are several delegates in the House of Delegates in Virginia that have really started working on this sort of extra junk fee issue to try to increase transparency, but also reduce the amount of junk fees.
Thank you. Oh my gosh, you guys are so good and on the fly. We got through a lot of our questions. So thank you so much. I know there are a lot of folks on the call and not everyone's question got answered. We do want to respect the 1 hour limit. But Jill Norcross has put our kind of generic email info@navaja.org. And I believe at least Larissa and maybe Catherine's emails were also placed in there. I can't track everything that's in there, but I think they are. And as we said, we will definitely be following up with more information from their organization and from ours. And we will continue to follow this issue. And there's a opportunity for us. We will consider doing another lunch and learn that's more immigration or ICE enforcement related in the spring as needed. So let us know if that's something you're interested in, and we will be in touch. And also, if you learned of this lunch and learn and you're not getting that information directly from us, that's another opportunity to email the info@navaja.org or go straight to our website, navaja.org, to get on our mailing lists. And you can do that by jurisdiction or the overall to hear more about these things and get our newsletter going forward. So we welcome you to do that. So, and thank you so much, Larissa and Catherine, for sharing your expertise. I know a lot of people are very grateful for the information and for the resources that you've provided. So thank you again for being here.